The defense wish to present evidence?
We do not, Your Honor.
Okay. All right. So that's going to be the evidence that you're going to hear. I need to meet with the attorneys briefly, and I say briefly, it may take a little bit of time to discuss the jury instructions. We've got a draft of those prepared, but it's going to take me a few minutes to get those done and to make copies of that. So, go back in, have a cup of coffee, relax. We'll be with you as quickly as we can. All right, everybody be seated. Mr. Segura, your attorney has now announced that you do not desire to present evidence. You still have the opportunity to change your mind at this point in time if you wish to present anything. Do you wish to present anything at this time, Mr. Segura?
No, Your Honor.
All right. All right, let's talk about jury instructions. I found a typo in the aggravating factor number 2. Just was an extra Y in there. What else have we found as to the jury instructions? Say.
Your Honor, I did have a question about the draft. We had the special instruction to number 2, purpose of avoiding arrest. I don't know if we received a final copy which included the additional language that the state had requested and the court had granted.
No, I need to add that in. About the primary motive.
Yes, sir.
Right. Frankly, I forgot that. Thank you for that. I will have that added in. What else?
Other than that.
Okay. As to the instructions, the defense have any issue with the instructions?
No, Your Honor, it's acceptable.
All right. The verdict form gets very complicated. We need to discuss that. As to aggravating factors, as to Ms. Peters, I don't see where the state has a basis to do the void or prevent lawful arrest as to Ms. Peters. I understand the theory is the children were killed to avoid that, but avoid them being able to testify against her being killed, but I don't see any theory by which she's killed to avoid lawful arrest, but I'll let you be heard on that if you desire.
No, sir. Except for removed.
I'm sorry.
We don't have any objection to it being removed.
All right, so I'm going to strike that. As to the children, I have a question whether the financial gain aggravator is applicable. I understand your argument as to Ms. Peters, but I don't see how that establishes committed for financial gain as to the children, but I'll let you be heard on that if you desire.
To the twins, we would agree to it being removed.
Okay. What's your argument as to Javante?
Well, the fact that child support, at least continuing child support, would cease upon his death. What we argued to the jury that, if he took custody of
He what?
If Mr. Segura took custody of Javante Segura, then he would in fact be owing any child support to himself. So there wouldn't be, he wouldn't have to deal with Randy Peters and have to pay outside child support.
Defense?
Your Honor, from my understanding, the judgment would have caused Mr. Segura to owe the state of Florida, not Javante Peters.
I'm going to strike it as all 3 children. I think it's a stretch to say. I mean, I think it is a fact. One of the witnesses did say it would cease upon his death, but I think it's a stretch to say that's what motivation was. So I'll strike those matters. Anybody found anything else in the verdict form? And they're quite complicated, so I hope everybody's read them. And if I've got something out of place or mixed up, let's deal with it now.
Nothing that I observed, Your Honor.
Defense,
Nothing, Your Honor. It's acceptable.
what's that?
It's acceptable.
Okay. All right, all right. Anything else from either side?
No, Your Honor.
All right. We'll go get those finalized and we'll be prepared to move forward.
Your Honor.